This is Attorney Mike Gravlin coming to you from Chicago, and today I'm going to tell you what the court won't tell you when you're on jury duty. Okay, so you got picked for jury duty, and now the court is going to instruct you on what you should be doing. Before the trial started, and even before jury selection started, there was a pretrial conference between the attorneys involved and the judge. And in that conference, motions in limine were presented. Now I do civil work and injury type law cases, but this is also true in criminal cases and any other kind of case you can think of. In a jury trial, the jury is the finder of fact and the judge is the finder of law. And this is sort of where the rubber hits the road on this distinction, and the judge has to make the decisions as to what the finder of fact can and can't know. And that usually boils down, there are lots of things involved, but that usually boils down to, is any piece of evidence more probative than prejudicial? Meaning, by probative I mean, does it help explain what's going on more so than it causes an emotional reaction that may sway things? And in that pretrial conference, there are decisions made as to what can and cannot be presented in front of the jury. And just give you a couple prime examples. In my area of law, for instance, it's standard boilerplate that there's no mention of insurance. Usually, if it's an auto accident, for instance, usually the defendant has insurance because it's compelled by law, but there can be no mention of insurance in front of the jury. There's also a few arguments that are simply not allowed, and they are just the sorts of things you would expect to hear. So if you think, why didn't the attorney make that argument? Just relax. The attorney probably made the best argument they could, given the facts and evidence and the applicable law and the rulings on the motions in limine. The other big one that I run into on a regular basis in this type of law is the police report. I've had several juries write a note to the judge and ask for the police report. That is not going to be in evidence unless the police officer testifies, which usually is not the case, because they were coming to the scene after the fact and they don't really have any firsthand knowledge to testify about. So sometimes it makes sense to call the police officer in, but if they're not really going to add anything, then their report is really just hearsay. That's an out-of-court statement offered for the truth of the matter asserted, and is not admissible evidence and cannot be shown to the jury. Also, there will not be any discussion of why there are certain witnesses, but a lot of times you'll sit through a boring foundation laid by an expert witness or chain of custody or some sort of thing that really seems to take a long time and not be relevant to the case. And it's not from the perspective of somebody watching it in the sense that it doesn't help tell the story, but it's foundational, and if you don't do it, then you cannot present the evidence that you want to argue about. Additionally, attorneys should be constrained by the evidence that they are going to produce or that they think is going to be produced by a party in the case. So arguments have to be limited to those things. In addition to that example, there's also usually a fight if, for instance, any of the witnesses have prior convictions, whether or not those can be in front of the jury. For instance, if someone has a felony conviction or a crime involving a dishonesty, that usually will get in, but it really depends on the situation. Conversely, if somebody has a 6-year-old misdemeanor marijuana possession charge, a judge is probably not going to allow that, and just saying it's not really to the point, and it's more prejudicial than probative. So if you're sitting on jury duty, just be aware that there are things that you can't know for the purpose of that proceeding, and you'll be instructed to review the evidence that's before you and only the evidence that's before you. And that's just part of our system of law. So in the event one of these prohibited things gets in front of the jury, what will happen is usually you'll have a sidebar, you'll go back and talk to the judge, and it depends on the level of violation, and in their judgment you can have anything from a warning to knock it off to a mistrial to sanctions. So it's not something that you want to do or play games with. I hope that was informative. I've gotten a lot of questions about this over the years and polled a lot of juries after a verdict and heard their questions right there, and also just people on the internet and that sort of thing. I field a lot of questions as an attorney, and I just felt like this is one that I should make a video about. I could get into more depth on it, but it gets pretty technical pretty fast. If anyone's interested, put that in the comments below. And if you like this, please hit subscribe, like, and tell your friends.